Good morning, Jolie. Good morning. Oh, I came on pretty quick. I'm so curious to see what the defense is going to say, and because they haven't even gave an opening statement, so be interesting. And then we may switch over and see what happens with the Karen Reed thing because they're having a hearing at 9:30 to see if that case can be dismissed. Which, yeah, I don't think that's gonna happen. Maybe we'll get some more people coming in. Maybe we won't. Maybe it'll just be us. How are you doing? I'm just playing around with. There we go. Oh, I'm okay. Okay. I hurt my back somehow yesterday, so I had a rough night sleeping. Barely slept at all. I don't even know what I did, if I did anything. Sometimes you can just turn and that'll just do it. But I'm gonna sit here as long as I can and watch this trial anyway. If they get started, maybe we should have waited. Da 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 da. We're expecting a pretty good snow. Um, Trying to stock up on I don't know, some food just in case we get snowed in. They're saying we're going to get anywhere from 2 to 8 inches. So that's a pretty big gap. So I'm going to say probably about 2 inches is what we'll get, 2 to 3. I'll be glad. I'll be so glad when spring is here. So glad. I hope they get started soon. I wonder what's taking so long. Let's see if we get to see what's going on with Karen Reed. Well, it ain't time yet, so I really shouldn't even worry about it yet. You're tired of winter too, yeah. It's every year. I mean, well, I know we go through this every year, but it's this winter has been odd, don't you think? Maybe I should share this out a little bit. I don't know. I don't know. I know that people they are confused by this case, and it really wasn't that public, unfortunately, even though it is so interesting in my opinion. And what are they going to say in the defense? I know I keep repeating that, but what is it? What can it be? Is he gonna admit to it? He can't really admit to it though, can he? He can't. Ugh. Wish the jury was able to know the whole piece. Me too. And I know legally, if we follow the law, they can't because one is supposed to not have something to do with the other, but it actually probably has a lot to do with the other. So, um, I just think that she's going to be looked at as such a great person when we know the truth. We know that she, well, she was in some of the pictures. And the thing is if she wasn't in the picture trying to do something to stop the picture from being taken, then she's absolutely just as guilty. That's, my opinion. My husband brought that up last night, and I was like, "You know what? You're right." And then if there was one picture taken after the first picture she was in, then she's culpable and should sadly, she's not on trial, and she should be. Yeah, a devil. At, and of course, she doesn't look she looks prim, proper, whatever. She does. That means nothing. Of course, her boyfriend didn't. Shoo. So now we wait. Maybe I should have waited. I don't know. I just assumed they would hurry up. Maybe we should look at some of the comments. They don't know anything either. What's the delay? I wonder what's happening without the jury in the courtroom. What is it? What? I'm told the defense is arguing to talk about the CP against the daughter. I wonder who told you that, because they would film that. Well, would they? Because it's a separate trial. They may not. I don't know. I don't they usually do though. Material had the murdered woman, her daughter, and other children. Yeah, one of her child's friends, I read. Certainly would steal the child too. Absolutely. Too bad they're not over here chit chatting with us. I'm over here talking to them like they can hear me. Can y'all hear me? When it gets started, we will turn off the comments. I bet if I was to write in there, "Hey, y'all come watch with us," I'd get voted. Oh, there's Vanessa. The judge must be in on it too. In on what? No. Okay, let's see. I'm gonna pop over and see if anything's happening with Karen Reed. I bet it's not, but we got one on Law and Crime, one on Court TV. See when it oh, they changed it to 9:40. I think they changed it to 9:45. It was 9:30, I thought. Hearing to dismiss. Hmm. What they tried double jeopardy, but they didn't find her innocent, so they can't do double jeopardy. I don't know. I don't know what they're gonna do with her. That's one I would love to go to, but Jim is like, I don't want you in Boston. Why? I've never heard anything bad about Boston. Like, it's not like a bad. And I think the trial in Utah, it got moved again. The Corey Richens. I think, didn't she fire her lawyer? I don't know. I don't know what we do. Do we just sit here and wait? Like, I know there's a lot of other streamers streaming stuff. It's hard. It's hard to know what to do, and it's certainly hard to stream a case. I'll tell you that. Judge calls for federal intervention in Harmony Montgomery case. Is this new? Despicable motion filed in Harmony. No, I'm sure it's not new. That's not new. We got 25 minutes before the Karen Reed case or stuff. Got my eye on it. We could see what they're saying about Harmony, I guess. I don't know. Let's see. We can figure out if it's old. It's gotta be.
Would you start us off with your thoughts, please?
I mean, who thought that the best part of this whole trial was going to be between the attorneys? I mean, these guys, they should just do a cage match and
So
be
this isn't
done with
Harmony
it.
Montgomery. This is the ASAP Rocky. I know nothing about ASAP. I know he's a rapper. That's all I know. And I know that he dates Rihanna. That's it. I just heard they're trying to use self-defense of another. Oh, Holden. I hope so. I hope so. That may be what's taking so long. I've got my eye on it, watching it pop up. They look. I don't know. Can they do that? Is that self-defense of another that wasn't there at the time and wasn't caught in the act? I don't know. They're having a motion hearing outside the jury right now. Way to be, Holden. Way to be. Listen, I just can't. Look, I hope ASAP Rocky, if he didn't do it, I hope he gets by with it. But that has nothing to do with Harmony Montgomery. So I wish they were doing that live. Come on. You are on it. Maybe I should have went. Jim told me yesterday, he said it's not too late. And I said, Jim, I don't know. I just in the middle of it, blah, blah, blah. Don't know where I'd stay. Don't know anything about South Carolina. We're expecting snow. Being there giving scoops. No, I would no more. If I thought this was going to take them 5 hours, I'd get in the van and go right now. Where would I sleep? I don't know. I don't know what I would do. Of course, ASAP Rocky had a real gun, not a prop. Oh, I know. Well, you know how gangster rappers carry around those prop guns. Come on. Could have been a BB gun. I have a coupon for Instacart, so I'm having just like 11 things delivered. 11. It seemed like a lot more than that, but it's not. Y'all know what I'm craving for dinner. Not y'all don't care, but I'm gonna tell you what for dinner. I want green beans and kielbasa, and I'm gonna put potatoes in there for Jim. I can't eat the potatoes, but it's so good the way that the kielbasa seasons everything. Mm. Hey Dale, good morning. You got your coffee ready? Maybe I should have made me some. I'll be back and forth a little bit once we can just get it started. Wish we had Instacart food delivery. We can't even get a pizza. We can't get a pizza delivered here. We can barely get Instacart. We like to never got it. And the only reason that I even it's because of my back. I didn't. Jim's panicking a little bit and because of the snow. So I didn't think I could stand to walk through the store and grab stuff, but I've already done a load of dishes and I haven't started clothes yet though. My back. I'm just gonna keep complaining about it till it fixes itself. Me too, Holden. These people who order Amazon and get it in the same day, I'm jealous of those people. Um, it's probably for the best that I don't, though, honestly. I'll tell you what I did order because I'm turning 50 next month. I I ordered this they probably sell it at Walmart, but I ordered it from Amazon. Uh damn, this cat. It's rock. What is it? We'll just chit chat while we wait. It is the advanced retinol firming serum stick. So let's hope it firms wrinkles, and my neck. Do anything, but I don't have to until I see this. Oh, bless your heart. Yeah, I'm trying. I'm fighting it. Not going down without a fight. Can't afford Botox, so. Well, no, I can't afford Botox, and I'm a chicken, so, you know. And once you get it, I guess you got to keep it up, or you just get your wrinkles right back. So what's the point? I need to go on Nightbot and fix this. The keychain and we're still doing the keychain and the magnets, and well, everything that we were doing before, we're still doing it. I don't know what the next trial will be unless it's I mean, we wait all the way to Stephen Stearns unless I can sneak my way to which it won't be a sneak. I'll just have to figure out how to get to Utah. Done fighting. My years of smoking and being in the sun, then losing weight. I'm a wrinkly mess. The losing weight is what got me this last time, Holden, for sure. Uh, I noticed that my chest has a few new spots on it. That's from sun, and it's probably going to get some more. But yeah, the losing weight. I quit smoking a lot of years ago, but the damage may have been too late. It's already done. I say a lot of years. But I think it's been about 7, 8 years since I've smoked a cigarette. Everything just what look, it does it. Yeah, it's not. It is what it is. Holden, you know. I even noticed the difference, and just last year and this year. The last time that I lost weight, which has been a couple of years ago, and this time it's been completely different. Just the way my body's handling it. It's like the elasticity said, "Nah, never mind. You're 50." And Jim's like, "No, it's perfect." I'm like, "Okay, that's all I need." Been married 24 years. He doesn't care, so I don't. Right, that's what I'm saying. I think the 27 years we're coming up on, 28, 27, I think. Been together 29. So yeah, 27. It's crazy how men age so differently than women. That is he has no sag nowhere. And I find that just unfair, but lucky. Come on, y'all, get through. Let us know what's happening. What's happening? 30-minute delay. What's okay? So they were only supposed to have a 30-minute delay on break while judge decides on defense of others' defense. Defense of others' defense is what they're saying over here. Defense of others' defense. Let's look that up. See if we can find anything on it. I'm going to share it and we're going to read it. Bob is 10 years older than me and has almost no wrinkles and just a few. Right, it sucks. It's not fair. Okay, so the defense of others is a legal defense that allows someone to use reasonable force to protect another person from harm. It's similar to self defense, but applies when someone defends another person instead of themselves. Well, so it's exactly what it sounds like, but elements. Let's read about the elements. An imminent threat. The threat must be imminent and not speculative. That may get them right there. Reasonable belief. The defendant must reasonably believe the force is necessary to protect the other person. That we can believe. Proportionate force. The defendant can only use force that's reasonable and proportional to the threat. But let's be honest. Was she alive? It would still be happening. No, it's not going to hold up. I hate to say that. Um, Related, stand your ground. Well, we know. Defense of others. Yeah, this ain't. I think it could only work if he walked in or yeah, well basically that's it. If he walked in on something. I would love for this to work because he actually, I feel like, was doing the right thing. And what does this mean, though, for the case? Does that mean that he's going to admit that he did it and why he did it? And unfortunately, the jurors are not going to know he did it and why he did, or they're going to know he did it, but not why he did it, I should say. Okay, we're not going to be able to go through all that. It's so small. But I did like the way that the AI thing summed it up. Have y'all noticed that the AI summary is not popping up on live streams anymore? That was so fun. I wish they hadn't have stopped that. Oh yeah, Holden, for sure. They'll have to. That's all they can do. They'll have to tell how she was abused and what they were doing to her, and they have the proof. But that's going to be a whole different case against that guy. So, and again, they're going to say the victim here is, what's her name? I went blank. Christina, and she's not on trial. I bet that's what they say anyway. Let me get my socks. Hold on. Right. The perv is assumed innocent. You're right. It sucks. It does. It just sucks. Oh, it's okay to be like Kokomo Corner. They're late too. They're late for good reason. They're trying to do, what do we call it? Defense of others defense, but it's on, yeah. Yeah, you're just not that late. Mm. So now we need to, let me cut this out. And I think we already know how the Karen Reed thing is going to go. I hate to act like I know it all, but they want to try her. That, I'm telling you, in my opinion, that state wants to try her. Um they're going to stick together. I don't know if she's innocent or guilty. I don't know, but I think it's interesting. It's going to be an interesting play out anyway. Let's see how much longer it's got. Well, it's live. I guess I could put it in while, let's see though. Are they just sitting there with that up too? Yeah, basically. No sense in even sharing it yet. They could dismiss that whole aspect. They could. And you know what? Maybe they should. If they're not gonna, I don't know. Just dismiss the whole thing. I think people know what happened, sadly. And I'm not convinced at not even a little that it was her. It just doesn't make sense. Usually if it doesn't make sense, it's not. I mean, I didn't put Karen Reed in the title, but I just thought we'd have something in the, nope, not yet. Let's see what we could find. Is Karen Reed going? Nope. The other one? Nope. Of course, we know Karen Reed wouldn't start right away. I agree, Holden. I agree. If she hit him with her vehicle, I don't think it was on purpose. It was dark. They were all drunk. I mean, who in that crowd is innocent? I think that's just a good question. Who was innocent in that crowd? None of them. All out drinking, driving, supposed to be protecting people. Mm-mm-mm. Hey, Stadius. Good to see you. I would say you're late, but you're not. Hazelton County, where 20-something woman committed suicide. Years later, they arrested a cop. Several cops had. Oh my goodness, that's so sad. I wish that we could get some info about the sheriff and the judge. That is the hardest stuff to find. If I could figure out how to do a FOIA and see if they would give me anything, but I don't know. Hey, Sammy. Thank you. Thank you. I appreciate that. Today I just took a bath and threw my hair up. Wanted to be comfy. Actually killed her because she was pregnant with this kid that's coming up. Oh, dang. Where did that happen, Holden? Oh, you said in that county. Never mind. In that county. Mm-mm-mm. Well, they definitely stick together there. And as we know, a lot of cops do. No offense if you're a police officer. But I was watching. Excuse me. Anybody watch? And I didn't watch much of it. The Gabby Petito thing, the new Gabby Petito thing on Netflix last night. I was flipping this morning and I saw a woman saying Gabby Petito was abusive to Brian Laundrie. Do you know if the 16-year-old who is pregnant by her 40-plus-year-old boyfriend has been found? No, I do not know that. But I think that would be interesting. Where was that at, Sammy? Gawk is right. Okay, nothing's happening over here at Karen Reed. Nothing's happening at Zachary Hughes. They're just sitting there. Okay, get me the name. And I will punch it in. Texas. There's a young girl that I know that her boyfriend's name was Juan. I know, well, I say I know, I'm pretty sure. I want to say she was 16, 17 years old. She was in her third trimester. They are 99.9% sure he killed her. He's in prison or jail right now waiting for the trial. And they have her very last footage of her going out, on the Ring camera. It's so sad to see that stuff. Beautiful young girl. And they said he wasn't happy about the baby. I should have wrote her name down, but I didn't because I feared it would keep popping up. I'm telling you, the comments over here are tearing her up. Oh, and there's a few arguments of fake pictures. No. I'm going to go check out the KR hearing. What's the KR hearing? Let us know. Come on. Another break. It's going to be a while before we see anything. Well, what do we do here? Sophia Martha Franklin. Oh, my goodness. Let me look. Was he married? Oh, no. 13 days ago. 40-year-old predator. That's Nancy Grace. Oh, Jim, my husband was telling me about this because she's from right around the same place as where I just got back from and where Summer Wells is from. Let's see if we can get any news on the Karen Reed. No, not yet. They say this one is going to be a while. Maybe we should go and come back. I don't know. I don't know, though. The Karen Reed one's going to be good, too. I guess what we can do is hopefully, yes, sad and gross. Yes. Well, I guess what we can do is just wait for the Karen Reed to see if it starts. Will they dismiss it? No, I doubt it. Let's see if I can. I mean, we can hang in here and see. It could be worth watching. Let's see. Nothing yet. Over on Karen Reed. Hey, good morning, Lori D. How are you? Very good to see you. In Texas. That's so sad. Did they run off together? No. Missing girl with 40-year-old yeah, they did run off together, didn't they? Is that what I'm... Let me see.
Our main goal at the end is to bring her home as safely as we can and get her back home as quickly as possible.
Right now, the frantic search is on for 16-year-old Sophia Franklin, the pregnant teen believed to be with the unborn child's father, 40-year-old Gary Day.
Wow. Yeah, they're together. Still arguing with the judge about defense of the child. Gotcha. And with Karen Reed, they're still waiting as well. They haven't started yet. Which this is, just a motions hearing, but still. What if it gets passed? She's, ugh. Thank y'all to the people who subscribe to my TikTok. Fun over there. I can go live now, I think, but I don't know what I would say if I went live on TikTok, so I don't think I'll do it. He wants CP pictures to be admitted. How are you finding this out? Is there anywhere I can stream this? Court TV gives updates. Gotcha. Come on, Karen Reed case. Let's go. Let's go. Court TV has it on members only. See if I can pull up a third Court TV. Let's see. Nothing to see there. No. Karen Reed still hasn't started. He's admitting it. He's admitting it? Defense attorney said Hughes was motivated to murder to save the child. He's admitting it. Okay, wait. He's admitting the evidence or he's admitting that he did it? The defense attorney said Hughes was motivated to murder to save the child. Oh, so he's admitting that. Okay. He's admitting that he did it, or he is admitting he's admitting that he did it. Wow. Wow. I don't know. I think I believe him. There's too much evidence that they were perverts. But that's an uneducated opinion of, I don't want anybody to, don't go by me. I don't know what happens if they don't want any evidence and that will prove it. Nothing. I don't know what could happen. I mean, because the jury is going to feel, well, even though it's the law, they're gonna feel like they were left in the dark. I mean, I would if I was on the jury. Yeah, I think he set it up that way too. That was up with the rose petals, which that not a great idea. I mean, I guess what people are, they're just completely forgetting about these Ring doorbell cams where everything you do, nothing is private anymore. People are gonna see. I don't know why he thought the guy would be so romantic he would spend that much money on roses. Come on. Let's see. Message this guy. All right, let's see. Karen, come on. Nope. Wait, yes, she did. Hold on. Yes, she did. Let me add it.
Number on this, I think it was just filed, the Commonwealth's opposition in response. Do you have a paper number? Okay.
Here we go.
I'm sorry, the opposition to.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument and you can give me that.
506.
Great, thank you.
That's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice.
Can y'all hear it?
We were following the court's instructions, meeting with Mr. Brennan after court the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present. If all the information was a download from some iCloud account, unnamed iCloud account, as long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, et cetera. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department.
Is that all they're fighting for?
File, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that in fact it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files.
I think the crazy thing is this is not the first trial for her. So they're still having to go through this and get certain proof. I don't understand that.
The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that because we would think that in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Mr. Brennan.
It seems like another effort to portray some type of injustice wrought upon the defense that half the facts are left out of the presentation. Mm-hmm. So to talk about reality, the reality is that I invited them to come download the DVR NVR where they full well knew that I had no idea if there was still video on there and why would they be 3 years later. And after they filed a motion making representations,
he seems upset,
that weren't accurate. I no longer had the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after, because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process. And I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later. So we were happy to do it.
Seems a lot.
And then
I don't know.
when we
I
got
don't
back
think
to
they're
the
that happy
office,
to do it.
the request changed under the spirit of Brady violations and due process. It was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay
Holden, do we have any
has been
updates?
because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
How quickly can you do that?
I imagine we could do it one day, but
Question.
today is, we have done by the end.
Was it taking 3 years?
You want to maybe, I'd be heard briefly,
Yes,
very, very briefly.
take your time.
Thank you. Mr. Brennan's confidence notwithstanding, I don't know what to say about that, pretty immaterial, what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. And we're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, you know, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video.
Mm-hmm.
Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want
That
the
October 24th,
Fourth.
did that video come with the metadata?
No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, again, I'm no expert. My understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. Just give us the metadata associated with all those things. It's not a hard ask, it's not a heavy lift.
There's
No reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves.
She's smiling pretty
So
big.
this isn't an issue where the government is trying to hide something or keep something from them. If it was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can provide. If they want to come, they're invited. If the court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs of what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the videos. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it.
Okay. Thank you very much. All right, Ms. Giannetti, the next one should be fairly quick and simple. The motion for Pro Hoc Vici. I asked you before when Mr. Alessi joined us, you have a rather vague good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that.
Right.
I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel? Thank you, Your Honor.
Okay, the next one's paper.
May I be heard briefly?
Yes,
May I be heard briefly?
yes, yes. So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but
Sorry
I
about that.
have some thoughts that I want to share with the court.
Okay,
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys
Oh,
in this
no.
case.
Judge refused defense of another defense.
There's a record that has been represented that the attorneys
we
in
kinda
Mr.
knew
Kearney's
that was
case,
gonna
Mr.
happen.
Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case, that there's an ongoing, long-term, implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been
Really,
harassed and
Holden?
intimidated,
Dang.
it is curious that that relationship exists, and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case within 24 hours.
You really are. You're doing a great job, Holden.
It was a violation of different material in that case. And so inevitably, you have Attorney Betterow, who will be serving two masters.
I don't know where Pammy B
He
is.
will receive
I
protected information in this case.
went
that is
live pretty
supposed
quick, so she probably didn't.
supposed to remain
She
protected
may still be asleep.
and not leaked and
Under her warm
distributed to the
covers.
media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. Then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government.
Yeah, me too, Holden.
And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial. And the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay. Ms. Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one I believe is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of
Good grief, I'm
Gretchen
so
Laws and/or Metro Court.
into this other one. I wish they would start. I want to see what happens.
Relatively straightforward, but I'll hear you, Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it
They are. I
transcribed,
think
as
they were
expect
making.
these
I
many
thought they were
parts of
making
the
another
trial.
motion to
The order
dismiss
was
it.
all the
That's what it
attorneys could listen
said.
to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay, there's no objection to this, is there?
No, Your Honor.
Of course, I'll provide the defense a copy if they want.
Yes. All right, so this is allowed. All right, so the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today. And today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us. And I would ask that the court take no action on this motion until we've had a chance to view them. And we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested.
Understood.
Okay. All right, so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So
All right, as
who
soon as
is
the other one
arguing
starts up, we'll
this
go, but
motion
they're still
for
there.
the defendant?
They're
I
still
will be,
waiting.
Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider. It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to, Ms. McCabe, it was never mentioned anywhere that she spent an hour at the home, the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed that that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue, and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. Secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed. So I take responsibility for everything that's in there. But we also make the point that with regard to, Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument. And he obviously uses derogatory language toward him as well. If we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but this is I won't say unique trial, but it's a rare trial that is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth's motion for sanctions.
Let's wait. When I said both, I thought the points that you made both.
Understood.
All right, so Mr. Brennan?
The court should enforce reciprocal discovery. You should enforce it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control.
Oh boy,
The
this is
reason for
boring.
that
Sorry,
is
y'all.
because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have
Hey,
obligations.
Heather King. Good to see you.
And that is why that language is in Rule 14A1A.
I appreciate
The
y'all being
Commonwealth
here.
seeks consult with somebody they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense because it's in my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides. And that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, you'll be
Oh, I know,
abiding by it.
Holden. I'm just reading.
Okay.
But
Was there any follow-up to that?
I don't know if we want to come back, what we're going to do.
The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jen McCabe, or Jennifer McCabe, I should say, revealing this link meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery comes in a trial, and I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right. Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Hughes is going to testify. This is going to be so good,
Your
y'all.
Honor, we filed a motion to compel certain discovery that is still
Okay,
outstanding.
it says
There's 10
you will
items.
see the
I'll
judge
address
on the
those in
bench
turn.
in approximately
The first
15 minutes.
request deals
All right, y'all.
with-
So
Good.
you have the Commonwealth's response, right?
Yes,
Where it doesn't object to some. Are you going to skip over those? Or
Yes, of course,
okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other
Hughes is going to
documentation
testify. That's
regarding
going to be
how
big.
the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have
what is he going to say?
video
This is
surveillance
gonna be
footage
good.
from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those
she's about
3
to cry.
productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts state police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos, but that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office
All right, I'm going to use the
investigation
restroom and get ready for
clearing
this
Officer
next thing.
Matthew
It should be
Farwell
coming
of
up
the murder of
soon.
Sandra Birchmore. There's certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper Guarino. Lieutenant Brian Tully. Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Guarino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Guarino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Guarino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that.
Hey, Mary Carl, love you too.
a
Hey,
witness
Debbie
motion
doll.
back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts
I'm refreshing.
retained by
I think the other
Commonwealth
one's starting.
in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to
Thank
the
you.
ARC
That means a
experts.
lot, Mary Carl. Thank you.
Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right. Mr. Brennan.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses. including the retired sergeant. And I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto.
Well,
And so they
on.
just throw out terms and words
It's been
for our
streaming for
audience
2
that's here
hours
on
with
our right
nothing.
to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to then now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case? Troopers work on many cases.
Right, so I'm reading in the chat over there. It says, it is, Heather. They have been trying to enter the CP into evidence, and I don't think it went well for them, but we got 2 different. Some are saying they're breaking for lunch. Some are saying that it's about to start, and some are saying that the defense is saying they will show Hughes did not act with malice. I don't know that they can say that without saying what happened because of how many times she was stabbed and the roses. So I'm not. Yeah, I don't know if that'll work.
He certainly has a public appeal to it because of the.
Yeah, it's going to be a really interesting day. He's going to take the stand, Heather, if we can. He took the life. He took the life of Christina Parcell, and he's going to tell you why. That'll be good. That'll be good. This Karen Reed thing is a snooze fest.
Harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady versus Maryland in Giglio, and most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth versus Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024. Please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement. Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're
I can
over
email that to the
500 at
clerk.
this point, so.
Yes.
All right. All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan? Sure.
It started. Let me look.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness.
Okay, let's get over there, y'all.
It's been a week, but it's been longer than a week. It's been years. Our client, Zach Hughes, has been waiting for a lot longer than that.
Here we
He's been
go.
waiting over 3 years, some 3 years and 3 months. As Mr. Mormon told you at the outset of this case, we are honored and privileged to be representing Zach. You're going to hear about Zach in the next day or two. You're going to hear that he's a very gifted and accomplished young man. He is 32 years old now. He was 29 when this happened. He's from a one. You've probably seen them seated back here in the courtroom throughout this trial so far. You're going to hear a little bit about his life. He was born in California. When he was still a boy, his parents took Zach and his brother, moved him to southwestern Virginia, where they moved into a small farm. And then they took on 5 orphan children who lived there with them. And you can hear that Zach was homeschooled. He learned the value of hard work and discipline as he grew up around the family farm. He helped his young siblings. His family moved to Greenville when Zach was a teenager. In Greenville, he finished high school, being homeschooled still. And you'll hear that his hard work and his discipline paid off. And he was accepted into a very fine college with scholarships. He went on where he studied music, and he won piano competitions. His emphasis was on piano performance. As an adult, Zach has had an accomplished career performing classical music and even recording classical music. So this is the time now for our case and for Zach to testify. But understand, ladies and gentlemen, that we have no obligation under the law or the Constitution to be doing this. This case actually could be over when the state rested. The state has the burden of proof of proving this case in every element of every charge beyond a reasonable doubt. We would not have to put up anybody. Zach wouldn't have to testify. Wouldn't have to put up any witnesses. In fact, if Zach were not here, his honor would instruct you that you couldn't use that against him. But we are going to do so. And Zach is going to testify because Zach has been waiting for this opportunity to tell a group of people like you what really happened, which is that he took the life of Christina Parcell. And crucially, he's been waiting and wanting to tell you why. Now, the why to a case like this is very important because it goes to the heart of the matter, and that is malice. Okay, malice is what makes a homicide a murder. And we heard from that from the prosecution's opening, as you recall. The prosecution said that Zach was mad. They said he had an angry heart, that he wanted to inject himself into this custody dispute of somebody he knew. But that's not why it happened. And that is not what you were going to hear about why this happened. Now, as we turn to our case now, it's important to realize that we could have handled this case extremely differently. Okay, we could have attacked the sufficiency of the state's case. We could have brought in an expert to talk about the DNA. Okay, we didn't do that. We could have challenged the identification evidence. And I want you to consider the professional from law enforcement, from the state law enforcement division, who testified about the enhancement that they did on the videos and the photographs, and how they were able to use this fancy technology to enhance and to account for the differences between sunlight and shadow and the distance. And after all of that, and after all of the technical work that was done, the conclusion was that the guy on the bicycle was 6'5", a big guy like him. Well, as you probably noticed, and as you will see, Zach is shorter than I am. On a good day, I'm 10 foot. I'm 6 foot, 5 foot 10 inches. Okay,
10 foot.
He's shorter than I am. Consider the other professional. There's one who spent a great deal of time looking at the enhancement of the person on the bicycle. And after all that time, what was that conclusion? That this person had a beard. It has to be a man. And they enlarged it, and they used, again, all of that technical information to take a look at it. This guy had a beard. This is before they had any suspect. Well, what do we know about Zach and what we learned about Zach? He was clean shaven. We know that from a couple of days prior, and we know that from a couple of days after. We could have attacked that. We could have attacked the identification from the neighbor. As you remember, a neighbor, after 3 years, came into court, and all of a sudden, after 3 years, was able to identify the man whose picture had been on television for the past 3 years. Had never told anybody even that she could identify somebody. And this was somewhere between 8 and 8:15 in the morning. And what you're going to find, ladies and gentlemen, is that couldn't have happened because the person on that bicycle was not even in that neighborhood for at least an hour to an hour and 15 minutes later. But we didn't attack that. We could have done that, and we could have made mountains of objections throughout this trial. And as you heard, we made very few, and we did not do it. And why is that? Because Zach wants to take the stand and tell you what happened. Now, the prosecution has told you that they will prove this malice in this case by showing you that Zach was mad, that he was angry. And malice is a key part of this case because malice is the very essence of the definition of murder. Okay, so what is murder? Murder is the killing of somebody with malice aforethought. And what is malice? The prosecution told you it's anger, that is madness, and that is a component of it. The definition, though, it is the killing of a person without just cause or excuse, the intentional doing of a wrongful act without just cause or excuse. And I want you to think about those words, that definition, as you listen to the testimony that you're about to hear in this case. The why to the homicide is very important because it gives insight into the person's heart.
Are they going to let
In this
him
case,
tell
you're
why,
gonna
though?
hear that the why was not jealousy or greed or a crime of passion or some other emotion. You're going to hear that Zach did not act like an angry heart like the prosecutor conjectured. You're going to hear that this was not done for money or any other personal gain or benefit, not to help out any kind of friend. You're going to hear that this was done for a just cause. And that's not malice, and that's not murder. Thank you.
Okay, so that's his opening statement. So what's going to happen now? Man, what are you going to do? What do y'all say? That he still didn't have the right to take a life, right? Mm. I wonder what's going to be allowed to be said. He's charged with he stabbed a woman 30 something times and then he put roses everywhere. Nanya. But the reason he did it is because her dad, oh gosh, there's a daughter involved and the dad had been trying to get custody. The boyfriend and the mom was involved with CP and he was trying to save the little girl. And he did save her. The little girl's now with her dad. I don't know, my love of crafts. But good to see you.
The witness is just making a phone call. He'll be right back. Ladies and gentlemen, I'm going to send you back to the jury room for a moment, and then I will be back with you. I really want to also thank you just for your patience. We've had a lot of legal issues that I've had to take up with the attorneys, okay? So I will be back with you shortly.
Uh-oh. What are you going to do? You're going to go to lunch? Help me to lunch. Welcome back, my love of crafts. You have nothing to be sorry about. We need to have a movie night. I was just thinking about that. Or maybe go, be in Discord and watch the Gabby Petito thing on Netflix. Yes, Nanya. He got to know the little girl and became friends with her dad and so we wait again. Mm-hmm. Off topic. What is that with all these planes? I know, Heather, right? It's crazy. All of a sudden. Yes, the child's alive. Oh, I think we're back. Yeah, I think what I think I read 2 were injured. Thank God they're okay. Let me go get a banana. I'll be right back.
Okay, welcome back. I would have kept you in here if I had knew I was going to get my answer so quickly. It is 12 o'clock. I'm going to ask that y'all return at 1:30. We're going to take a break, enjoy your lunch, and then we will pick up at that point. Again, I remind you of everything that I punished you about before, and do not begin any deliberations or discussions about this case. Okay, we'll see you back at 1:30. Thank you.
Yeah, this weather's for the birds. I am freezing. Just waiting on this snow. I don't know. There was a lot of they got all their WhatsApp messages, and I don't think there was any messages like that. The dad did get him to harass the mom, though. And he did do that. Well, he took the child to the other country and had her for 3 months, and then she fought and somehow got her back. Odd that he would put it on a fire alarm, but okay. I'm sorry. Let me mute. Chewing. The dad, they haven't proven that the dad did anything wrong. Oh, so we're out for lunch. Well, of course we are. All right, y'all. Well, we'll take a break. Hey, Rosebud, did you watch your interview on? I didn't. All right, y'all. Well, it's 11:30 here, so 12:30 my time. We'll meet back here. I'm just gonna leave it running. Please talk amongst yourselves. Get you something to eat. Get you some coffee, something like that. Well, any minute, y'all. They should be coming back. Anytime. Hey, Pam. Good afternoon. Oh, I know. I got one that I have to remake because I had to cancel it while I was gone, and I'm just dreading it. Still waiting on them to come back from lunch. I do think Wendell's going to be coming up. Perplexed #1 fan, let me thank you again for the super chat. Hey, KB Bells. Enjoy your work. Boo. Follow-ups after a lovely hospital. Ain't that great, Pam Malone? Any minute. Come on. Randy, the Karen Reed case was stopped by the judge. Prosecutor gave her something. She said, it is of grave concern and could affect defense counsels, affect them negatively. But I don't remember the big word she used. Oh, no, really? Affect defense counselors. Ooh. Oh, I wonder what it was. I wonder if Wendy saw it. She's supposed to be coming up soon, so. They will be back in a week for ruling. She was pissed. I bet. Oh, come on. This is going to be so good. My patience, it's wearing thin. Profound effects on defense counselors. Really? I wonder what in the world. Excuse me. I got the sleepies. Now we gotta wait a week. I wonder if Wendy saw it. Let me text her and see if she's coming up. Surely it's clipped somewhere. A refresh. I don't see it yet. We've been waiting on this one all day. Oh, come on. I don't want to miss this. If he takes the stand today, and I think I got Wendy's most of the way caught up to what the trial's about, as much as, could. Third person defense. I don't know. I thought they said it was definitely going to take the stand. I don't know. It's going to be interesting for sure. And they said he has not been able to wait. He can't wait to tell y'all why he did what he did. So And now we're just like, sorry. I know I'm boring right now. I don't even know what to talk about. I mean, come on. I'm afraid if I turn it, something else is going to happen. Yeah, that's what I want to hear is his explanation. Like, we know, but he can't say. So it's just, and I don't, alleged, can you get up there and say allegedly? I don't know. I don't think he can. And if he messes up, then he could ruin the whole trial. They'd have a mistrial. Mm. I shouldn't be having a really hard time with this one, though. He can't mention CP. Well, then I don't know what his defense can be. I don't. Guess I could go through my feed and see who's live. Blah, blah, blah. Oh, the ASAP Rocky trial is on Verdict Watch. Didn't know that. I'm all into that Justin Baldoni case. And Blake Lively. Like, I'm team Justin all the way. I don't know why, but I just am. Yes, Holden. For an hour and 17 minutes. I don't know what to do. Do I keep streaming? What do I do? What do I do? I'm still just looking around. I must be on a channel instead of home. Let's see, subscriptions. see if it's it. Nope, still's not back on. Nothing. Tam's live. I'm sure she's been vile and disgusting. I don't know if I should stop it, start dinner, and start a new one. I don't know what to do. I should have drove there, I guess. No, not in a snowstorm. Nah. Because if it snows, I'm out. It'll be worth it once it starts.
Hey.
Hey. We're still, there's still waiting.
Waiting for them to come back from lunch?
Yeah.
Then why are you texting me?
I'm
thinking I'm late. I'm like, okay, I'm coming. Sorry.
Oh no, I texted you
We're just
because
sitting here doing nothing.
well, yeah, basically. But the reason I texted you was because Holden was watching the Karen Reed thing,
and let's see, she said that something happened, and they had stopped it. And let's see.
Well, go to like Emily Baker or something. Let's find out what happened. Know what I'm saying? Like, let's go to her channel because we need a lawyer to explain it to us. So I usually go to lawyer, or Emily Baker.
Did you hear it?
No. I was
something
doing
about that could hinder.
Came up.
Something that it could really hurt the defense.
Yeah, that's why we need to get to a lawyer and ask and find out what happened. So I'm trying to find that right now. Where the hell is Emily Baker? I thought she was live with this.
I found her.
Okay, you want to bring her in? Or? Yeah, she's live with it.
As long as I don't get in trouble.
Which I have no issue with.
But
if we look back earlier in the relationship,
where are we? Let's see.
What we see back in March 20.
Okay. All right. You brought it in. Sorry. Okay.
There are
I don't know if we're allowed to stream her while she's live,
Jackson,
so I was just going to listen to
Daniel Wolf.
Yeah, I don't think we can.
Thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainers.
Okay, so we're listening, right?
Okay.
Yeah.
Okay.
But there's
Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment.
What date was that?
How
they
is that
on a
close?
Reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now,
yeah, this seems like before trial. This seems like before trial, last trial. Offered, you guys said he said March 22nd, 2024. Great.
It's the relationship, and Commonwealth should have an even playing field.
Oh.
Saturday, June 22nd.
He makes me want to take he's the ASMR.
Meaning you like him? You like that voice?
No. I mean, it just puts me to sleep.
Oh, puts you to sleep.
Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attach my D&T list.
Okay, she's explaining it right now. Are you at live? Are you at the
of what my response would be. Again, I thought your
The
questioning
chat's
during the
going
voir dire was
crazy.
fantastic. So please
Almost.
feel free to make whatever changes you feel necessary.
Oh boy.
Yeah. Right there.
Okay, listen to what she
Now, this
says.
isn't information provided
Okay.
by the defense in reciprocal discovery. This is information provided by the federal government after numerous
Oh,
requests,
shit.
suited requests.
What,
And
Emily? What?
So, oh boy.
What?
Oh boy. Well, I don't know if we're code red yet, but what Alan said to the court was, hey, we only discussed scheduling. The feds turned over emails that are showing that Alan and the experts are having conversations beyond scheduling.
Oh, that's not good.
That's
Damn it.
not good at all.
Damn
All right,
it.
I'm going to back up because I want to hear the date of the first one. I'm sorry.
And that's the defense?
Yes.
Chat that we're going to go over this twice. But that's not good. That's not good at all. So let's continue. I'm going to back up because I want to hear that date of that email because the dates are going to be important.
is that there are conversations between the defense, Attorney Jackson.
I backed up a little bit.
And Daniel Wolf, who's one of these ARCA witnesses.
Look,
thank you so much for taking.
With everything in court, y'all, we're gonna wait and see. We're gonna wait and see. So, no spoilers, please, chat. Thank you, moderators.
I have to tell my chat that too.
If your comment gets deleted, it's because the mods see it as spoilish. No spoilers.
Yeah.
Thank you.
I tell my chat the same
Taking
thing.
the time
Don't
to get on the
spoil
phone
it.
with me
We want
this
to find
morning
out
pursuant to
together.
our conversation. Please
Well, I
feel
think
free
she ended it.
to forward an engagement letter
Oh,
to
she's
this
still
email
going.
address. I will get that
So,
countersigned
not
and
her,
returned to you forthwith,
the judge.
along with your retainer as required.
That's not odd to me. So the defense tried to hire the ARCA experts and the Fed said no. Okay.
Commonwealth, as I understand it, was not aware of any promise, rewards, or inducement
It seems that wasn't made.
or payment. They relied on a reciprocal discovery order of this court.
Right.
for
It seems
information.
that wasn't made.
Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward.
Man.
Now,
I'll tell
not
you
the
what, she's a
opinion.
genius to be able to
It
get
troubles
what
me.
she
It's
got
the
out of that
relationship and
from that.
Well,
Commonwealth
because
should have
she's
an
a
even
lawyer.
playing
We're
field.
not. That's why she knows what she's talking
Saturday,
about.
June
No,
We
it's
don't.
just
22nd,
it's just so
Daniel Wolf writes,
Mhm.
Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic,
That's
so
not
please
good.
feel
It
free to
was.
make whatever changes you feel necessary.
So they spoke after the voir
Now, this isn't
dire.
information provided by the defense in reciprocal discovery. This is information provided
I make
by the federal
changes to my
government
case
after
testimony.
numerous requests,
You're not
suited
supposed to do
requests,
that.
Yeah, I thought
and
that's what
and insistent
That's
the
not
best I
good.
can to get as much information as I can. We then are provided an outline.
Now,
An
here's the
outline.
thing. Just pause for a second. Here's the thing. If the expert is offering all of that and Alan Jackson didn't ask for it, I think a case could be made that, look, yes, he's an expert. He doesn't understand law. He offered these things, but we did not entertain them. We didn't look at them. We didn't, just, find me the email of me actually prepping him. Find me the email of me responding to this and telling him what to say. Find that email. You won't, because we didn't. He offered some things. I didn't even entertain it because I know that's not okay. I know we know not to do that. You know what I mean? Like, maybe he can say that. I don't know. We don't know yet. I don't know yet because I don't know what his responses were to these emails. But if
well,
he's
they're
if
gonna
they're,
sorry, there's
Let-
gonna be another trial. The Holden put it in chat a while ago when the next trial is.
okay, hit play. Let's finish.
of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline,
If the experts are sending Jackson an outline of what the questions should be on direct examination, that is witness preparation. That's witness preparation. And
If
if
Alan-
the court had said,
If Alan doesn't use them, though, is it? Or is it just he didn't know that he wasn't supposed to send those things? I don't know. Keep going.
there is to be no communications, and that's what the court said. There is to be no communications
never mind
between these
then.
experts except for voir dire,
Never mind.
and there's preparation. That's not good at all.
Yeah, that's not good at all.
is then
How did they get his
the
emails?
outline
That's
with
amazing.
remarks from this independent expert who knows nobody.
Right.
So we see in the margins in the notes, this fair-minded, objective witness says,
Brennan, I'm just going to say, if you have the smoke, the commentary is not necessary because he keeps quipping. And if he keeps doing this at trial, he's going to piss people off. He keeps quipping with this fair-minded, objective expert.
Yes, I caught that too.
The snark.
Yeah, it's very
If you have the
snarky.
smoke, the snark isn't needed.
Yeah, you don't need
so
to
not
do that if
being
you're winning the
not being able to
argument, sir.
inspect the vehicle is something that's not uncommon in your line of work. And he writes,
You know, he's really excited because he gets to read this. That's
Oh
what's
yeah,
exciting.
he's so
Yeah,
happy right now because the defense has been kicking his ass up and down the whole street, and he's so finally happy that he gets to punch back. Finally, he's got something he can finally smack them with because they've been kicking his ass for months. He's a little sour about it.
Not any comments. Not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
The date of that?
It's not dated. It's not dated.
All emails are dated, sir.
Was it an attachment to an email?
Emails are dated, sir.
It's not dated.
How could it
Could
not
that
be
have
dated?
happened after the trial then? Because if it's not dated,
how could it not be dated?
what? Could it have been a conversation after the trial? It could have been.
The TUI request is a recent February response, but they send random documents. There's no real accounting.
I think she's explaining it. I don't know.
Now,
You
I'm
know
not
who's
saying
gonna-
that undermines
You know who's going to know the date? Jackson.
the conclusions of ARCA.
Get him up there.
I'm
Let's
not
ask him
saying they're not
questions.
qualified witnesses, but it certainly shows some bias. I've turned over
It
a
doesn't.
lot less in this
It
case.
doesn't necessarily show bias.
Yeah, I don't think
What
it
it
shows
shows to
bias.
me is
He's trying to be
communication.
prepared.
And they said there was no communication. There might have been communication since the end of the last trial till now. So I'm going to wait and see. But
yeah, that's why the date's going to be important.
Yeah, we need to know what the date
Right.
is, and all emails are dated. So I don't believe there's no date. You're lying. Come on, Jackson.
it definitely
say
shows communication. It doesn't show that they were hired. And TUI requests from the feds are so difficult. But these communications could have been since trial. The language of it indicates it's during trial, need to show the jury.
Mhm.
That implies that it's ongoing during trial.
Could be next.
But if the
Friday.
feds are turning it over, then there should be dates. But Fed TUI requests are like, here's some shit. I understand the Commonwealth's frustration. And if Jackson said, no, we've never had a conversation and these emails show that he did, that's also a problem. It doesn't necessarily mean there's a bias, but it does mean that there was communication where no communication is what was represented. And that's shady.
Case.
So we'll
than
see.
this. Another comment.
Oh,
Would be
let's
fair
hear
to
'em.
say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty.
Another quip.
Yep. He's such
That's
a
a
salty
problem.
asshole.
Mm-hmm.
That's going to be interesting if they testify again.
It certainly shows some bias. I've turned over a lot less in this case than this.
Uh-oh.
Another comment. Would be fair to
This
say
is
because you had a
interesting.
lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of
True.
lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine.
Oh no!
Okay, that's not good.
Yikes.
That's not good.
Yikes. That's communication between
That's
those
not
experts before he testifies.
That's communication and bias.
Uh-huh. And witness prep and every other thing you're not allowed to be doing. The hell?
That's fine. Shh. Don't
Quit.
tell them.
Really? Don't tell them.
You
Nice.
qualify as an expert in court
Wow.
before? Yes. I realized my testimony. I said it 20
Well, that was a
times when you
quip
asked how
from
many
him.
I've been
He
qualified.
that wasn't written. That was I'm watching it. 'cause I
Okay.
can't show it. Yeah, that was a quip.
I misinterpreted the question. My fault. 11 trials.
You need to knock that shit off.
Positions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925.
That needed to be disclosed.
That's not Trimble.
When is that bill from? Because if ARCA was paid, that has to be disclosed.
Uh-oh.
That's a huge problem.
That's
This
not good at all.
seems to be, and hopefully the defense will clear this up. This seems to be between voir dire and testimony, but the court said no communication and no prep with these experts. If there was voir dire and then communication and then testimony, that still needed to be turned over. There is a requirement for reciprocal ongoing discovery. Just like if the Commonwealth had conversations with the witness after testimony, which they shouldn't have.
Okay. Are other trials back?
It's hard to think of an analogous
Hey, let her just finish the sentence,
circumstance
okay?
That's not completely improper. But if a witness hadn't been called to testify yet, and the Commonwealth had a conversation with them before they went on the stand and they said, oh, by the way, I remembered this thing. The Commonwealth has to go to the defense and say, before this witness testifies, you need to know that they just disclosed to me XYZ. And then if between the voir dire and the testimony, there were additional witness statements, those additional witness statements need to be turned over.
That's not trial by ambush.
And if there's payment,
That's
that needs to be
getting
turned over.
So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works.
God, shut up.
Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens.
Yeah,
I don't
Brennan's
care if the
pissed.
witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
Hey,
They are entitled to discovery.
All right, please.
Oh, the judges are going to be happy.
The judge got really pissed.
That's what I want to know. Can we watch that or not?
Well, the
judges are going to be happy about that.
Okay,
The
you
judge
go
is
to the
taking
other
a
trial.
recess.
I'm going to step off the panel for a second because I'm going to watch this and I'll be back in a minute.
Okay.
unit. When you're in a specific unit within the sheriff's office, do you receive specialized training associated with that type of unit?
Yes, sir.
Right. And so when you were on the road in uniform patrol, did you receive specialized training related?
They're definitely in trouble, Holden.
And when you were in the unit of the crimes against children, did you receive specialized training in that discipline?
Yes, sir.
And
Can y'all hear it?
let me show you.
It's a little bit low.
Let me show you Defense Exhibit 65. Just take a look at this for identification only.
Yes, sir.
Investigator Bevel, for example, that is the report you drafted for the purpose of the harassment investigation. Is that correct?
It is, sir.
And so this is of the kind of report you would draft depending on what investigation you were conducting or what tasks you were performing with the sheriff's office.
That's correct.
As an investigator, are you familiar with a phrase called the lead investigator?
Yes, sir.
And ultimately, the lead investigator is just that the investigator on a case who is ultimately responsible for the investigation. Is that correct?
Yes, sir.
And in this case, Investigator Sparkman would be deemed or likely be the lead investigator. Is that correct?
That's correct.
Were you also the lead investigator in another case in connection with this case? Let me ask it a different way. On October the 19th, 2021, did you become the lead investigator in another case?
Objection. State your objection. Objection. This is going to fall under your previous ruling. Okay. I will sustain the objection.
Okay. Your Honor, due to Your Honor's previous order with the restriction, I'm going to move on, and I'm going to move on.
How about moving over to a microphone?
Investigator Bevel, you testified, as you said, in the state's case in chief, and that was just last week, wasn't it?
Yes, sir.
And I would imagine you're still familiar with your testimony in the state's case in chief.
Yes, sir.
And I'm going to talk to you about that testimony. And specifically, I want to refer to a specific portion of it. Do you remember during your direct examination, you testified about mailers and the contents of mailers that you had been provided in the early summer and through the summer of 2021. Do you remember that testimony?
I believe so. Are you referring to the mailers as what I was given by post?
The pictures of the woman.
Yes, sir.
And you testified that those mailers had nude photographs of Christina Parcell in those mailers. Is that correct? Remember that?
Yes, sir.
And I've got a transcript. I want to ask you specifically about this exchange. Do you remember being asked by Mr. Wilkins, when you first got these photos, let me back up. Do you remember testifying about the fact there was a website listed on the photographs? Do you remember testifying to that?
Yes, sir.
And do you remember Mr. Wilkins asking you about questions about different fonts and different placement? Remember that?
Yes, sir.
Do you remember Mr. Wilkins asking you this question? Now, when you first got these photos, did you attempt to try to find the website on there? Do you remember that question?
Yes, sir.
And you testified, yes, sir. You remember that?
Yes, sir.
And then do you remember Mr. Wilkins asking you, how'd you do that? And you testified, I just typed the address into one of our computers in the office. Do you remember that?
Yes, sir.
I was hoping he was going to be on the
And do you
stand.
remember Mr. Wilkins asking you, and what did you find? And you testified that the website no longer worked. Do you remember that?
Yes, sir.
And then do you remember Mr. Wilkins asking you, so you put belladondigiorno.com escort site and put it in your computer, and you responded, yes, sir. Do you remember that?
I believe so. Yes, sir.
And he asked you what happened, and you said, it just redirected me to another escort website. Do you remember that?
Yes, sir.
Okay, so they're going to allude to it, right? That's what it seems like.
And then then he asked you, were any of those photos on that escort site? And remember, you testified no.
I'm sorry, I got an objection. Can I
I'm almost done. I'm one more line.
I'm going to let him ask this question.
You remember Mr. Wilkins asked you, were any of those photos on that escort site? And you responded, no, sir. Do you remember that?
Yes, sir.
And then just one more.
Mm.
Do you remember he asked you, was any pictures or were any pictures of Christina Parcell on any of those websites that you found? And you testified, no, sir. Do you remember that?
Yes, sir.
Because they were children. You don't know what to say.
Isn't it true
Uh-oh.
that in the harassment report that I just showed you, defense exhibit?
Your Honor, I've got another objection I need to make. I need to just put it on the record.
Your Honor, this is
I'm sorry.
I bet he wants to tell. I bet he wants to tell what he saw on those websites. Betcha. Betcha. And we're back to the wall. He didn't even say why he was what was the objection for? Like a toddler who got in trouble. Hey, Stadius, welcome back. Yeah, I do too, kinda, to be honest. Hanging out, just listening. Yeah, me too. I really, really wish they'd get on with it, though, and get him on the stand, which I wonder if they're stalling. Well, no, I think they're trying to plant the seed to the jury. But the jury, I don't know, they can't really go by that. They have to go by what they absolutely have evidence for. It's barred from it because it is only alleged right now. It hasn't been prosecuted. So they can't, can't say it for a fact because it's not a fact yet. I think we're back. Yeah, we are. Hey, welcome back, Shamat.
So again, let's pick up where we left off. I had reminded you of your testimony from last week, wherein you were asked the following about typing in this website. And you were asked what happened, and you testified it just redirected me to another escort website. Then you were asked, were any of those photos on that escort website? And you testified, no, sir. And then you were asked, which you previously testified to, were any of the pictures of Christina Parcell on any of those websites that you found? No, sir. You remember that testimony?
Yes, sir.
Isn't she in your report on the harassment allegations?
Your Honor, I'm leading.
Your Honor, he's an adverse witness, 611C. He testified for the state. He's a member of the Greenville County Sheriff's Office. I have every single right to lead him pursuant to 611C.
Your Honor, he is their witness. They call it.
In
What direct examination witness. So I'm going to sustain you.
Oh.
All right. Well, I'm going to show you Defense Exhibit 65 again. Look at this bottom paragraph. Would you please read what I have bracketed to the jury?
Yes, sir. I photographed the 6 envelopes and the contents of the open ones. The open ones were addressed to Brad Post. One contained black and white nude images of Parcell with the address checklist. The images have a web address of http://belladonna.escort-site.com. I checked this web address and it was not valid. It redirected me to another escort site under a different URL. The other contained several of the same images, but were not in color.
So is it true, based on this report, that you were redirected to other websites that had the same images that were in those envelopes? Isn't that correct?
No, sir.
Okay. Isn't that what you said in your report?
It's poorly worded on my part, but I meant the other envelopes. Same images were not in color.
What are you saying you meant?
The images that were in the other envelopes, not another website.
So didn't you say that you found these on the internet? Isn't that what you said in your report?
No, sir.
Tell me again what you said. Yeah, please read it again to the jury. Read it again.
It's okay if I go to the relevant part instead of
Yeah, they've got a bracket there.
Okay. Photographed 6 envelopes and the contents of the open ones. The open ones were addressed to Brad Post. One envelope, or it just says one contained black and white nude images of Parcell with the address checklist. The images have the web address of http://belladonnadigiorno.escort-site.com. I checked this web address and it was not valid. It redirected me to another escort site under a different URL. The other contained several of the same images, but were in color. Now, like I explained, it's poor wording on my part, but I was referring to the other envelopes contained several of the same images, but they were in color. I wasn't referring to another website.
And in your report, you don't distinguish between envelopes and websites, do you?
Like I said, it was just poor wording, but I was referring to just other envelopes had the same images, just in color.
That was poor wording then.
And isn't it true that it is very possible that those images could have been online and just taken down at the time you tried to look at them? Isn't that true?
In another website? Is that what you're referring? Yes, sir.
You haven't missed much yet, Holden. Hopefully it'll get better. He's already been on the stand for the prosecution.
Those are all the questions I would ask investigative level in this context.
How'd it go?
Good, really good.
Okay.
I have her on pause because she's going to go back and kind of go through the whole thing again. So, and she talks really slowly for me, which is excellent because she gives very good information. But for me, I need to listen to her on like 1.5 or something. But what happened at the very end was the prosecution said, "Oh, whoops! I said the federal government gave me these emails. I was mistaken. It was the defense team. The defense team gave the prosecution those emails. Clearly, they know about them. Clearly, they're not surprised that these emails exist. So the judge didn't know that before she went out on break and came back ripping pissed. She was like breathing heavy. She was so mad. Then the prosecution says, "Oh, wait, I said the federal government. I didn't mean that." He's acting like the federal government snuck in and got these emails and that this is your big gotcha against the defense. And they were given to him by the defense. So the judge is like, "Okay, well, I need copies of these, everything that you just read before we leave, before you leave the courtroom. And we're going to meet a week from today." Defense asked to change it to add one more day for a conflict in schedule, I believe. And I think that's what they're going to do. So we're on a cliffhanger at the moment, but it felt really slimy to me that the prosecution tried to make it look like this was some sneaky business from the defense when the defense gave them these emails.
Yeah.
They're not trying to hide anything. They handed them right to you. The fact that you can't come up with a date is odd. How do you not have a date on these?
They absolutely did act like it was some huge gotcha because I thought it was a gotcha.
Did. Absolutely. And so did Emily Baker. And obviously the judge did too. She left, came back 20 minutes later, ripping pissed, smoke coming out of her nose, so mad. And then to come to find out that I'm sorry, I got these from the defense, not the federal government. My bad. You're such a slimy, and you were a slimeball during that whole snarky comment, making it seem like you got the defense in some kind of scandal when they're the ones who turned over the shit in the first place. They obviously know you have them. They're fine with you having them. They gave them to you. So shut up. So now I don't know what's going to happen. The judge seemed to calm down a tiny bit after realizing that. Probably now wondering what the hell the prosecution's trying to pull.
Yeah.
She's going to go back and look through everything. The problem is that if between the voir dire and the testimony, he wasn't supposed to have any conversations with the witnesses or the expert in this situation. It was the expert. He wasn't supposed to have any communication with the expert. So if these emails happened between those two dates, then we've got a problem, because the judge did put out an order, and she's going to probably go back and review her own order and make sure that's what she said, and see where these conversations happened, because
Yeah, she's gonna want the dates.
she's going to need the dates, and they're going to be on the emails, asshole. So you can she's going to get copies of them now, sir. So you can go ahead and just, I don't know, get your Photoshop ready and start deleting dates, because she's going to see when these happened and when they didn't happen. And it's going to be either a gotcha or you're going to look like a damn fool. And I hope it's the latter. I hope you look like a fucking fool. You deserve that with every smarmy, snarky quip that you're lobbing toward the defense when they're the ones who gave you the emails.
Yeah.
Acted like the federal government gave it to you. Sit down. Ridiculous. Absolutely ridiculous. So that's where we left off. Where are we here?
So this guy's already been on the stand for the prosecutor, and
who is this?
I think he's a cop. And he was going through the pictures that, remember I told you they were sending pictures to try to intimidate the mom to give custody of the little girl. And they were uploaded on a website, and I guess the biological dad did that.
Why would the bio dad put pictures of his child up on the website?
Not his child, his ex-wife.
Even so, that's revenge porn. You're not allowed to do that.
No. I mean, they can't prove it. I don't know that they can prove it's him, but they're pretty sure it was him. Or possibly it was the defendant. I don't know.
Well, what was the reason?
To intimidate her into giving him the child.
Okay. Yeah, that's revenge porn. You're not allowed to do that.
Yeah.
Okay, please, Corey, briefly. Did you ever find naked photos of Christina Parcell on the internet when you checked?
No, sir.
It's because it didn't exist that you could find.
Not that I could find.
No further.
No, that's good.
Oh, okay, Jen. Interesting. Wow. He's all, believe me, I looked.
Yeah.
I used my VPN and everything. Couldn't find them.
Well, he had the envelopes and pictures in his hand.
To your previous ruling, I would like to present some information.
You know, this guy's dying to talk. Ugh.
Dying to what?
Tell the truth.
Oh, yeah.
And is it another break? Sure is. Son of a gun.
What's the break for? Can you go back and see what the judge said?
Yeah.
How long this break is, or is this for the rest of the day or lunch?
They've already had lunch.
Okay. Well, it seems like it's too soon for another break. So I wonder what happened.
Your report, you don't distinguish between envelope.
But we're in color. Like a
that taking that.
Damn. Damn, in my Florida Evans voice.
Please, Corey.
So the judge doesn't say anything. They just mute.
That's the way it's been going.
The judge doesn't say how long they're going to take breaks for?
No.
Oh. All right. Well, that was a waste of time. Sorry.
It's all right.
You can just hit the live button. It'll take you all the way to live.
Well, where is it?
Next to the mute button. Next to over here. Go to the left. Down where the play, pause, rewind. See where it says live? Right there. Click that. That takes you all the way
I just thought it was telling me it was live. I didn't even know it was a button.
Well, when it's a red button, when it's red like that,
Uh-huh.
go back and look at it. See
Yeah.
how there's a red button right there? That means
Mhm.
you're live. So go drag the stream back and that button will go away. Like click right there. Yeah, just click. Okay, see how it goes away?
Yeah.
It's gray. Okay, now click on live.
And now it's
And
red.
it takes
Cool.
you right to the red. Yeah, so that's how you know you're live.
I had no idea. No clue. You didn't know that
Okay.
either? Holden,
Well,
good. That makes me feel better.
so do you want me to pull in Emily then and listen to what she's saying? Since we're waiting or what?
Well, yeah, we can. We just gotta make sure we cover it up. I don't wanna.
Yeah, we don't need to. I just want to hear the audio.
Okay.
Okay, let me pull her in. Okay. So there it is. Just put us on top. Okay.
Okay.
This is interesting. Again, it looks bad, but we don't have all the information. And so I try to stay away from that looks, other than saying that looks bad, but we need more information. So thank you all for knowing that it's really hard. It's really hard to wait. Would, I can't believe the judge is like, we'll come back next week. Damn it. I went.
But she agreed with the judge though, because if the judge right now wanted to sink the defense, she would, tell them stand up right now and explain this. But she's not. She's giving them a week to go prepare whatever their response is going to be.
Right.
But that was before she realized that the defense actually gave them this stuff. So I don't know how mad maybe she's still mad. Don't know. But it does change things that the defense is the one who turned these emails over, not the federal government.
Yes, he is, Heather King. Yes, he is. Well, I'd say that she was mad and then calmed down, maybe possibly calmed down a little bit, and then got even more mad when she came back and found out. Yeah.
Right, but mad for a
And it's
different reason
like,
now.
you know what?
Now she's mad at the prosecution,
Now she's like, I don't even want to see y'all's faces till next week. Whatever.
That's
Do what
that's
you
how
gotta
it
do.
seems to Emily too. Emily kind of feels the same. She's like, you know what? I'm timing out, time out, everybody. We're taking a break. We're gonna to be continued, and we will talk next week because I'm done with all y'all. I don't want to see any of y'all's faces for the rest of the week.
Ow. I want answers now. I want answers now, Your Honor. Now.
Yeah, we all do.
Damn it.
All right, let's
go. I might just merge. Maybe both and be like, I was lied to.
It wasn't noted as unresponsive, just when I.
All right.
And it was striking that it wasn't noted as unresponsive, just when I read the materials. And
we are jumping back in time, back in time to listen to what Brennan has to say about the defense conversations with the ARCA experts.
Okay, and Brennan is the prosecutor.
Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials.
All right, I think I need to back up a little. I'm going to back up just a little bit more.
So that the experts could testify. If the defense is going to be a proponent.
Because again, here's what I appreciate in Brennan parsing this. Brennan is saying, I'm not saying that ARCA can't testify. Brennan's argument has always been, we need the discovery. And if the defense is a proponent of the expert, we're entitled to the discovery. So you can't halvesy it. You can't have it both ways. You can't say this isn't our expert if it's really your expert. If it's really your expert, then you need really your expert. Brent Woodchick, I appreciate this. I want more inches. I want more than two. Well, two's enough to kind of shut things down. Also, my kid's sick. Can school just be closed another day or two so that he can get better and not miss any more school? Because damn it, this season, we have missed so much school. I'm ready. For those of you north of Nashville, I know. TDOT's not going to get it clear. I know. It's not. I'm ready for a few snow days.
And I'm sorry, but the prosecution has their nerve demanding evidence, or well, not evidence, but demanding discovery from the defense when the defense has been the one that can't get anything from this prosecution without a court order. And even then they don't get shit. They've asked for the metadata for years of shit. They've asked for these video files and the metadata from that, the logs of the people who had access to these videos. Nothing. They get nothing. It's ridiculous. And now they're going to boohoo and cry because they didn't get something about one of the experts. Like, you guys are all, you're so damn childish. It's ridiculous.
So what the Commonwealth is arguing is, look, you can bring your expert, but if you bring your expert, I need the discovery. And if this isn't your expert, I still need the discovery. But it seems like this is kind of your expert because you are chatting. So, Raven, I appreciate it. I definitely have thoughts on this case. I have thoughts on this case, but we'll call out lawyer fuckery on all sides. And if there's lawyer fuckery, we'll call it out.
And there is plenty to go around.
I don't know if there's lawyer fuckery. So we'll see. I have thoughts about this case for sure after seeing the first trial. But we're going to listen to Brennan's arguments again and see what we learn. Trial is supposed to start. The new trial is supposed to start April 1st. The last trial started May 2024. So those June conversations would have been during the last trial. Jules, if travel expenses were paid, that had to be disclosed. But I think I don't remember. If travel expenses were paid, it needed to be disclosed that they paid travel expenses. That might have been disclosed. It might have been brought up during the first trial, and I just don't remember. I don't remember everything. But guess what? We covered it, so we can go rewatch. It's on the internet. So we can find out between now and next week. All right, let's see. I'm going to let Brennan.
Do you have that?
Yes.
All right.
Brennan, I'm going to let you argue.
Exclude employees of ARCA, paper 497, and the opposition.
We're listening to his whole argument.
505. So, Mr. Brennan. Sure.
All right. Brennan, I'm going to zoom you a little bit.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case.
We're rewatching.
But there has to be a minimum requirement of reciprocal discovery and discovery
Agreed.
before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that
Also, I didn't disagree with that based on how it was presented last time. I can understand why the Commonwealth is mad about it, but the court said, this is my ruling, this is my remedy. But if the ruling wasn't adhered to, then there's problems. RS asked, can we watch AJ's statement after the hearing? If we can find it, we can watch it.
there is other things.
Team
that are
Baker's
relevant,
looking for
like
it.
Compensation, promise, reward, inducement. Whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about. That there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery.
I'll message her, Holden.
Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken.
This is before the voir dire. And I think the timing is going to matter a lot in this. This is before the voir dire.
To them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined.
He's reading the transcript.
And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
This is from June
12 and 28/13 of June 10, 2024.
This is
Now,
before
having
the voir dire at trial.
Some familiarity with the federal government.
So this is before what he's reading from the transcript is the colloquy that happened before the voir dire of the ARCA experts between the court and the defense from June 10th, 2024. That's what he just read. And the defense had said that they coordinated their testimony, which I took to mean coming to court to give testimony, and their background, but they had not interviewed them. Let's continue.
I don't understand.
Seemed to me based on my.
You don't understand what?
Was this before the judge said no communication or after?
I think it's before. I think that's what she's saying.
Oh, well, they're okay then.
They could be. We don't know the dates of these conversations. What he's reading right now is the transcript of the trial. That was before the voir dire. So we don't know the dates of these emails, though, yet.
Limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery.
Hear that? Federal government?
So that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day.
It's still funny to me.
So I filed the TUI letter, comprehensive TUI letter.
And filed it,
And
I mean,
it was delayed.
he gave it to the court.
And over a long period of time with requests and deadlines, I finally received a response that was unresponsive.
Shocking. The federal government gave you something that's unresponsive.
It was striking that it wasn't noted as unresponsive, just when I read the materials and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there.
Excuse me, the trial's on YouTube, sir.
Is she re-listening to that?
Let
Is
us
she?
continue.
There's email
Yeah, she rewound so we could re-listen to it. Yes.
Oh, okay.
correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required.
Okay, they tried to hire them. Does them trying to hire them shock me? No. Let's keep going.
Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment.
It seems that didn't go
They
well.
relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will.
And that seems accurate. So here's where we're at. I'm going to keep breaking this down. We're in March 2024 before the last trial. The defense is aware of the ARCA experts because they testified at the federal grand jury. It seems that the defense reached out and said, we would like to hire you. And the ARCA expert said, per our conversation, send over a retainer and we can hire you. And then the AUSA has said, time out. You are our witnesses. There are some issues with you being the government's witnesses on the federal case and potentially being hired by the defense on the state case. We would like you to pause those communications. And it seems that the ARCA experts reached out in March and said, the U.S. Attorney's Office had told us that we can't continue these conversations. So far, this isn't wild. Let's continue.
Move forward. Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes,
this is what I'm worried about.
I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
This is what I have concerns about. This is going to matter, and we need to run it back to what did the court say? And I do not know. This is from June 22nd, 2024. This is in between the voir dire and the trial. So this would be after the voir dire, before the testimony of the ARCA experts. Because I think they testified that Monday or Tuesday. So this is in between the voir dire day of the ARCA experts and the testimony of the ARCA experts. And they're having communications with Alan Jackson. Any communications at that point should be turned over. So if there are communications happening in this window, they should be turned over. The question is, did the court order get violated, or is it a discovery violation? There are two questions here, because the court said you can't prep with these witnesses. That order should hold across the voir dire and the testimony. So this might be an issue. And just so we can clear it up, the MMAC research attorney in the chat, I've just dubbed MMAC that. Many of you in the chat have pointed this out, and thank you to everyone who has. Voir dire day was the June 18th, and they testified on June 24th. The testimony was after the weekend. So this is in between, this June 22nd date is in between the voir dire day and the testimony day. This is potentially a problem. Do we know how much of a problem? I don't know. This is potentially a problem. So let's continue on. Figuring out, Casey said, but this was turned over. If it wasn't turned over on June 22nd, it's potentially a problem. It's turned over now, but it's potentially a violation of the court order then. It's turned over now. It doesn't stop it from being an issue then. If it was turned over then, that's different. If it wasn't turned over till now, that's different. So we'll see. If it was turned over then that's different.
Information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline
He said Sunday.
Of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know.
I'm curious who provided an outline. For all of you asking the date of the email, this is from Sunday, June 22nd, 2024.
An outline of questions and answers for a direct examination.
Back this up.
And an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth.
Again, if the expert is sending the attorney a list of questions, that's a witness statement.
What follows from this outline,
if that outline's in that
is
same
then
email, which it
the
might be.
outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes,
Take Florida Gray.
this fair-minded, objective witness says,
The commentary, though, Brennan.
so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the.
This is witness prep. Here's the issue. Is witness prep an issue? No. Is witness communication an issue? No. Is the findings from that expert something that would normally get turned over? Yes. Is the full detail of that conversation something that would always get turned over? Not always. Is this an issue because the defense told the court that they did not have conversations with these witnesses? Yes. Though I, to best of memory, believe that representation was made before the voir dire. So these conversations might be in a gray zone after the voir dire. These communications themselves are not an issue. The fact that these communications might be in violation of a court order is an issue. The fact that these conversations were represented to the court that they might not have happened may be an issue. Does that make sense?
Why would he lie?
He's
not going to lie, especially when he knows that somebody is going to find out. I don't think he's lying. I just don't believe that. And maybe I have, maybe I'm biased because I really like Alan Jackson and I think he's, doing a great job as her attorney or whatever. Maybe I'm a little biased. Maybe that's what it is, but I don't know. But I don't think he would lie, especially when it's so easily found out. Why would he lie and say he had no conversations with them when he clearly has? And then turn it over to the prosecution.
No.
Why would he
Right.
do that? That makes no sense at all. If he was trying to hide it. I just don't buy it. I don't believe he was trying to hide anything. Why would he risk something like that? Like, that's a big risk. For what? You don't even need it. Like, I don't know. I don't feel like he would do that. What do you think?
No, because like you said, why would he lie and be caught?
Right. Things get found out, man. You don't do shit like that in secret, especially with against a prosecution that clearly would love to, drown you any chance they get. Like, I just don't see it. I don't see it.
This might be the gray zone in between the two. Because the best of my memory is the defense represented before the voir dire that they didn't have a conversation.
Oh, Holden, don't get me wrong. I believe attorneys lie all the damn time. 100%. I'm saying though, and yes, I mean, you guys know how I feel about expert witnesses. I've been more than clear. I can't stand expert witnesses. I think they go there doing the job. They say whatever they're paid to say or whatever they're supposed to say. That's how I've always felt about expert witnesses, even before we started doing true crime stuff. But I believe lawyers lie all the time. But this particular issue, I don't understand why he would lie when it's so easily found out.
Yeah.
That's what I'm talking about.
With the witness, but there was also a court order saying you cannot prep these witnesses. Talking to the witnesses after might be an issue.
Direct examination, I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough information from the material.
Because this is witness prep.
It wasn't necessary.
This is witness prep.
Need to show the jury it doesn't matter in this case.
The date of that?
It's not dated. It's not dated.
I think
I find that really
that was probably turned over with that email. Not dated is important, but if this happened in June, it might be a problem. If this happened after June, it might not be a problem. We'll see.
The TUI request is a recent February response, but they send random documents. There's no real accounting.
And then I think based on what we heard after this, and again, a document contained as an attachment to an email, the document itself might not be dated, but if it's attached to an email, you can find the date of the email.
Yes.
It seems that he represents this is coming from a TUI request when this came from the defense, which he clarifies later. Because I imagine the defense was like, we turned that over.
Yes.
Now, I'm not saying that undermines the conclusions of ARCA. Or not.
There's
I'm not
discovery
saying they're not
issues here.
qualified witnesses, but it certainly shows some bias. I've turned over
It shows prep.
a lot less in this case than this.
Oh, stop it.
Yeah,
Another
it's an
comment.
issue.
Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
But what is the date of that, Brennan?
Exactly.
Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925.
When that bill is turned over and when that bill is for is important to me.
That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify.
He is truly overdoing it.
I don't
Yes.
care about their opinions.
Yes.
But I care that
I
it's
think you do.
unfair, imbalanced, and hidden.
That's
And
also
the
fair.
Commonwealth, like the defense, is entitled to discovery. So if they can produce the
You're gonna
discovery,
keep banging the
I'd
table.
welcome ARCA.
All right, I'm going to take a recess before the response.
And the court's pissed. The court's right to take a recess. We're going to hear what the court has to say one more time. The court's right to take a recess when frustrated. We need more information. This might be a massive issue. this might not be a massive issue. This might be a violation, direct violation of the court's order, but we need the languaging of the court's order and we need the timing of everything because we need to know. And I saw Jessica W, your comment makes perfect sense. It was just in all caps, which is hard for me to read. And Jessica W in the chat said the money was for hotels and flights. If the defense paid for ARCA's hotels and flights, that has to be disclosed to the Commonwealth. That has to be disclosed. So if that wasn't disclosed, that can be a problem. I'm going to see what the court has to say again. Then we're going to get to questions. You guys have a lot of questions about this. Because the court's pissed. Is the court most pissed because it might be a violation of the court order? Yep. The court's mad. Mad.
Right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today.
Mad.
At 11 o'clock in the morning. You can tell me now if that is impossible for you. And
Brennan's going to say more. We're going to let Brennan say more.
The federal authorities have been kind enough in the past to allow me to have copies of everything. Would you be kind enough to call over there or check with whomever you were dealing with?
Federal authorities. See, she's in her mind, she thinks that they got this from the federal government. They did. They got it from the defense themselves. And here she is asking for, can you call over there and ask them if they'd be willing to share this with me? And my God, ma'am, you've been duped and you don't even know, and you're already so mad.
Past to allow me to have copies of everything. Would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of.
You guys,
if I could,
I'll get to questions. I'll get to questions. I'll get to questions. Don't worry.
December 4th, we sent another tour request, 2024. January 6th,
Brennan's
we filed
not
our
done.
notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th, 2025. I think I said the federal government.
Yeah,
you did.
You did. You did. You said the federal government, and it was the defense.
Yes.
Say the federal government. So the February 13th emails, no. He was provided the emails on February 13th from the defense. Hold on. That was just a few days ago. So the defense provided those emails, but the emails are not dated. The original emails don't seem to be dated February 13th. That's when they were turned over. I'm going to back that up to hear it again.
From the U.S. Attorney's Office saying that the contract had ended with the ARCA experts.
Which is interesting.
And that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th, 2020.
And that is a large correction that
Yes.
those emails came from
Thank
the
you.
defense, not from the feds.
Yeah, that's a big
I think
deal.
I said the federal government.
You
It was
did say the
defense.
federal
February
government.
13th, 2025, they sent us the emails
Dumbass.
and the direct examination outline.
So the defense sent the emails and the outline.
You know how much self-control it must take for the defense to not stand up in the middle of that and go, ma'am, he just said it was the federal government. It was us. We gave him that stuff. I don't know what he's talking about. Like, they have to just sit there quietly while he takes his whole ass turn saying all this wrong information.
Talks even slower than he usually does. Yes.
Right. With his snarky comments and everything. And they don't even get to defend themselves. They just have to sit there and wait. Oh, so frustrating.
The date of those emails is going to be very important. We're not going to probably know the date of all those emails until we get to the next part of this hearing next week, but it matters.
We reached out to the federal government again because I was curious about the change in position on February 6th.
The federal
that
government or the
contract has
defense?
ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it
Move
day
it, move
to the
it.
26th instead of the 25th?
Let's see if it's the 26th. I mean, I guess I'm here.
It would have to be at 9 o'clock.
Ah! I yell and does not like to be up early. My schedule doesn't matter. There's also an Adelson hearing that day. The 25th, there's no other hearings. My schedule doesn't matter in this. I'm being hyperbolic, but you know. I'm going to try to see what date we get to.
Hand up the discovery that was
Thank you.
provided by the defendant reference by.
Oh boy.
Oh, great, thank you.
Is there any way
I mean, if this is happening on the 26th,
We can
sorry,
do the
Donna.
afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Johnson.
He's the one on blast. He's not going to be on Zoom. His ass is in the hot seat. He's not going to. He's not going to zoom in when this is about him.
Zoom.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's scheduling. If we could do it live, I'd rather do it live, but.
I mean, he should get to it. He's the one being accused.
You're going to have to accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
Ma'am, just a moment.
All right, we're going to get to scheduling issues. I've told you multiple times, I had a case with 11 defense attorneys in one part of the case and 3 defense attorneys in a different part of the case because it was in 2 different jurisdictions. Scheduling took half of our day.
Are they back?
Scheduling 11 defense attorneys was like herding kittens.
Nope.
Without treats.
Can you believe that?
It was a nightmare. All right.
Wait.
This feed is going to end because my amazing producer, Miguelina, told me that it cuts out before they finish scheduling. All of us want to know what the schedule is. So we're going to switch feeds real quick to make sure we get to the scheduling because we all need to know when we're coming back because I am deeply invested. Y'all are deeply invested. We're invested. So we need to know. We need to know. All right. So we switch feeds real quick to see when we're coming back to court.
All right.
I've
So we'll
never.
see everyone.
I'm sorry.
We're not done
just on behalf
scheduling.
of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
Mr. Alessi's like, I came all the way down from, at least Alessi can take a train. I don't know if he does or not, but at least Alessi can take the train. And Alessi's the court's like, we're done. We're done.
Yeah, she's out. No,
Done.
don't
But at
even
least
ask.
Alessi can take a train. Jackson's got a bit more travels, but Jackson chose to be on this case too.
All right, 11 o'clock on the 25th.
Thank you.
11 o'clock on the 25th. Lawnards, that's a win for us. Lawnards, 11 a.m. on the 25th. Aha! We're not
Good
going
to
to be
know.
conflicting with Donna Adelson's bond bail hearing. For everybody who's like, Emily, are you covering XYZ case that has documents? No, we're just live court right now. 11 a.m. to 25:25 to continue this shit. Woo! Baby. All right, let's let this roll through to the end real quick. Damn. Today got unexpectedly feisty.
I love
So
when
that's
that
11 a.m. Eastern. That means I'll be around 10.
happens. I love when that happens. I love when court gets crazy and everyone is, all riled up. I love it.
Yeah, me too. And but see, that's what we thought was happening with the other case.
Yeah.
After we sat here for 2 hours and waited.
And they're still not back.
There's no.
Are they coming back? I mean, we don't even know why they took a break.
No, we don't know anything. I imagine they're back there arguing about how to keep CP out of it, how to keep these people testifying, but keep CP out of it. And they
I don't know why
have
she
to, I
wants
guess,
to keep me
but
out of it. I don't understand why.
because it's alleged.
So then say that. Say it's alleged. I mean, that's his reason for doing it.
Well, I agree, but I guess that they think once that seed, once that's planted, it's not going to go away, and they're going to get off. He's gonna.
Well,
I don't
maybe-
know. I don't think he'll get off. He'll get a much lighter sentence than.
Who's choosing his sentence? The jury
Which,
or
I don't know.
you don't know. Well, I mean, you can't argue jury nullification. You can't, I mean, you can't do that. So it's, I mean, it really, honestly, the law is the law is the law. You killed somebody.
Right.
You don't get to get off just because you had a good reason.
Yeah, you don't get to, do vigilante. I know A Time to Kill was a good movie and a great book, but it wasn't
Right.
the true story.
But it's not real. Yeah, it's not a documentary. And
Yeah.
you can't just kill people.
But I guess, but I mean, I guess we could just end this for the day. I don't know. Do we sit here another 3 hours? I don't think we do.
No, we don't even know when they're coming back.
No, they're
We don't even know
giving
why
no
they went on break.
updates, no nothing. I'm starting to get. No.
Yeah.
I wish that I do wish they were being more open.
Is this not a big case out there?
guess-
I would think it's huge.
I would think it would be huge.
Yeah.
But maybe it's not. I don't know. I know I hurt my back yesterday, so I'm just gonna get off of here, and I still gotta cook, man.
Okay. Yeah.
But
Well, let's just.
I'm gonna rest my back. Thank you for coming up though, and maybe tomorrow, Holden, we'll get to see him on the stand. I hope.
Well, I mean, if they come back on, are we going to come back or no?
I don't know if they come back on and it gets good. Yes.
Okay.
I'll have my dinner going. Yeah.
Okay. Sounds good.
All right. I'll see
All
y'all
right.
later. Thank y'all.
Bye,
Thank
guys.
y'all for hanging in here.
Bye, everybody.